Hello, I'm Tom Gosling, Executive Fellow at the European Corporate Governance Institute, and I'm here today with Eilis Ferran, Professor of Companies and Securities Law at the University of Cambridge, to discuss her paper Reconciling Shareholder Primacy and the Interests of People and Planet, which she co-authored with Pedro Schilling de Carvalho, Assistant Professor in Financial and Environmental Law at University College London. So, Eilis, welcome.
Thank you.
In your paper, you compare two approaches to encourage companies to act more sustainably. So one of these focuses on making changes to company law and directors' duties. So in a UK context, that's changes to Section 172 of the Companies Act. And the other focuses on the adoption of sustainability regulation. In brief, what's the argument that proponents make in favour of reform to company law and Section 172?
So thank you, Tom, for inviting me to talk about the paper here. It's great to be here. So in terms of the proponents of reform via company law and Section 172, so I think Section 172 is quite famous, but just to very quickly summarise what it requires. So it requires directors to promote the success of the company for the benefit of shareholders. In doing so, there is a enlightened element to it in terms of having regard to various factors, including community, environment, reputation for high standards, and employees, of course. This approach critically doesn't displace shareholder primacy. So the benefit of the company is anchored to shareholder interests. The others are secondary. They are merely a have regard. Section 172 came out of a debate about shareholder versus stakeholder interests before the Companies Act 2006. That debate has continued. And in its modern form, is perhaps most associated with the discussion around corporate purpose, which, of course, is something that Professor Colin Mayer of ECGI and other places is perhaps a leading authority on. It's been very instrumental in informing the work of the Better Business Act, and it's been subject of major work by the British Academy as well. And many companies have adopted purpose statements. You can see corporate purpose sitting there alongside corporate strategy and corporate values as part of the managerial thinking. And that's perfectly compatible with Section 172. But what advocates of change would say is that Section 172 is too weak because it's permissive. It doesn't require sort of other broader interests to be placed alongside shareholders, and that is the gap that needs to be addressed through changing 172 so that employees, community, environment are put on the same footing as shareholders rather than being mere regard factors set against shareholder primacy. Advocates would sometimes say that this change would be a small or a simple change to company law. But the problem with that is that if it's only a small and simple change, it won't actually have any impact. It'll be a gesture. To make it really impactful, you'd have to do a lot else besides. So others, and I would include myself and Pedro and I in this category, would argue that we can understand the motivation behind this, but really it doesn't work without an awful lot of very serious change behind it as well.
Maybe we'll come on to that a little bit, because in your paper you argue quite forcefully that pursuing reform of Section 172 would take us down a rabbit hole. And you say that this position is reinforced by the findings in an insolvency case, BTI versus Sequana. So why do you think it's a rabbit hole? And actually, what's an insolvency case like Sequana got to do with your argument? It's not immediately obvious.
Yeah, that's a really good question. So just to begin it, look, we don't discount Section 172 completely. We think it is a useful reminder to directors to think about things from all angles. There are reporting obligations related to that. We think it's useful as a kind of well-intentioned moral compass, and that has been said of it in the literature. We also credit it as being part of this conversation around standards of managerial conduct, around societal purpose of companies. And that conversation has changed norms. I referred earlier to corporate purpose statements being adopted voluntarily by many companies. I think Section 172 has contributed to that. It's been part of an awareness raising and an informing sort of exercise. We would also acknowledge the frustration with its limitations and have a lot of sympathy for that. But where we diverge, why we disagree, is in thinking about what's the most fruitful way to get meaningful change and why we get to the rabbit hole. Going directly to the point about why we mentioned Sequana in our paper. So BTI and Sequana, famous for clarifying that the duty to promote the success of the company for the benefit of members becomes modified in an insolvency context and becomes a duty also to take creditors' interests to be considered and to be considered alongside shareholders, not just as a have regard factor, and eventually that creditors' interests will displace those of shareholders. So why do we think that's important? Well, we think it's important in a broader context for these reasons. First of all, Sequana is, I would say, the most important company law case that we've had in a long time. There are over 160 pages of really thoughtful analysis by the justices of the Supreme Court that really give us a lot of learning about the state of our company law in general. And our takeaway for the purposes of this paper is that reading Sequana serves as a really stark reminder of just how tightly woven into the fabric of our company law shareholder primacy is, and underlining therefore the immensity of the challenge. Right. And I maybe expand it just a little bit further, just on one example. So if we think about the governance implications of the Sequana duty. So when we read Sequana, we can see that the shift to creditors' interests has major governance implications. So the duty of directors to have proper regard for creditors' interests is based on their economic interest in the company and the shift that happens on insolvency. It's a major governance shift in the sense that once that duty is engaged, shareholders can no longer cleanse directors' wrongdoing by ratifying what they've done. Right. And that cleansing power is a really important one. It comes from shareholder primacy. It reflects entitlement to control and to profits. But once you get to an insolvency situation, that cleansing power has to effectively go away because it is not compatible with creditors' interests and their economic claim in relation to the company. So to get the right incentives, shareholders have to lose their cleansing power. Now, when we compare that to Section 172, we don't see any of that at all. There's no governance shift at all. The have regard is merely that. Shareholders don't lose any ability to make decisions on behalf of the company. And that leads into the broader point. If you really want to make a big difference through company law, you have to address those governance questions, the role that we ascribe to shareholders, the importance of shareholder stewardship, the ability to appoint and remove directors. All of those things come onto the table if you want to make a meaningful change to company law. And the economic implications of that are potentially very significant. If we're going to change the structure of our governance for companies, if we're going to take away shareholder power, there are potential implications of that for cost of capital, for the competitiveness of the UK as an incorporation jurisdiction. So we would be very fundamentally changing our corporate law system. If we think that what Dorothy Land and Elizabeth Pullman have said about the US corporate governance machine also applies to the UK, really it is so deeply embedded, it's not going to be shifted easily. We just don't see that the UK government in the current climate would be receptive to changing or opening up a debate about changing corporate law in this way. And even if they did, I don't think we'd end up with anything very dramatic, because we can look at the precedent of the 2006 Act for that. So we could spend a lot of time in the rabbit hole.
That's great. So, I mean, so Sequana really just emphasizes the sort of, in a way, the naivety of the idea that just changing a few words in one paragraph of the Companies Act will somehow transform the way that companies operate. And so then this leads you on to the fact that actually the better place to focus is on sustainability regulation. And in part, you argue that because it complements company law and actually influences the way directors' duties are interpreted. And I'd like to explore the two main channels for this that you cover in your paper. So the first is that sustainability regulation changes the likelihood and role of enforcement under company law. Can you say what you mean by this?
Yeah, I am going to preface this because there's been a lot of analysis done by other distinguished lawyers exploring the possibility of enforcement. Our take on this is premised on recognizing that there are limitations in both private and public enforcement. And we're essentially pragmatic about that. You have to work with what you have, is our overarching approach to this. And we think that regulation's role in defining the perimeters of corporate activity that is lawful and in facilitating enforcement, both public and private, is part of a mix that facilitates this complementary interrelationship between shareholder primacy and the interests of people and planet. So we don't see enforcement as the only element, but we do think it's obviously has a role to play. We would argue in our paper, we make this point a number of times, that the increased granularity in regulation that's lessening the gap between science and its legal consequences is informing the substance of what we can expect of directors in discharging their duties. We think it's really important that a lot of the language of the sustainability regulation is focused on risk and the management of risk, because we think a lot of the issues in the sustainability regulatory agenda looked through a risk lens emerge as ones that have impacts on shareholders themselves. And that oversight liability, I mean, it is worth noting that in contrast to the US, the UK, judged by a negligence standard, we're not saying that a single compliance failure is going to lead to directorial liability, but serious, persistent compliance failures set against this background of increasing regulatory expectation, we would argue is potentially going to make it easier to argue that there are systemic weaknesses that are not compatible with what could be reasonably expected of directors, even when you factor in the reluctance of the courts to second guess business judgments.
So you've covered the sort of in a way the stick, right? So the potential for enforcement, and actually linked to that, you've already talked about the potential for increased potential liability. But maybe the carrot is that sustainability regulation complements company law by leading to more learning by directors. This is another point you make in the paper. Can you just expand on that a bit?
Yeah, I mean, I think I regard that as one of the key contributions of the paper, because I think the enforcement side has been covered quite a lot already. We were motivated to write the paper by a feeling that perhaps there was an underestimation of the positive force of regulation, and the fact that there are what we describe as regulatory guardrails that have a dual function. You know, on the one hand, making it easier to potentially identify non-compliance, but on the other, providing guidance to boards of directors in trying to make sense of how to most effectively navigate these new and emerging types of risks. And that we develop in a number of ways. So we argue that regulation is improving standards of sustainability literacy at board level. And we say that that is both good and bad news for individual directors. On the positive side, there's on-the-job learning. And that should help directors to develop and deepen in-demand knowledge, skills, and experience. Companies are looking to appoint directors with skills in this area, to ensure that they meet their responsibilities. And that has to be set against the bad news for directors in terms of potential of rising liability. So we do think that it can reduce the learning curves, sort of by addressing these blind spots, provide valuable frameworks for risk-based decision making. One of the advantages of regulation is that it can bring efficiencies in terms of standardized expectations, which is good for sort of companies and also good for measuring and assessing issues of concern. It can provide a way of distinguishing between those who are credible in their commitments in this area and those who are not. And so we think that unless directors are just simply going through the motions, then, working with this material will inevitably seep in to how they make their decisions and make them more sensitized to the non-financial, impactful sort of consequences of their sort of board actions as well. And we think the way in which regulation is quite dynamic. You can see that, for example, in the evolution of transition plans and how they are moving from a high level to more detailed, as a good illustration of that. And going back to what we were talking about earlier, endless debate about changing company law compared to a regulatory agenda that, of course, has some challenges and difficulties, and it's not a perfect solution in itself, but it is essentially dynamic and is maintaining sort of momentum. And frankly, I don't think that sort of there is any groundswell anywhere to sort of remove all of it, because the positive aspects of it are recognized and valued.
I think your implicit assumption that directors try to do a good job and authentically fulfill their duties is generally a fair one in my experience working with boards. But I guess one thing I wanted to follow up on is that in your paper, what you refer to as sustainability regulation, mainly refers to the various types of disclosure regulation, including taxonomies and transition plans, as opposed to real economy measures. And the concern I have is that when we have major unpriced externalities like carbon emissions, then the interaction that you get between regulation and directors' duties that you described can only have a relatively small effect, because if the economics kind of overwhelmingly undermine sustainable activity. So, for example, while the mechanism you described may have made a company like BP bold in its climate commitments a few years ago, it's economic reality that has ultimately won out in its recent kind of retreat from these. So how far can the mechanism you describe in this paper really take us?
You are absolutely right. We are not suggesting that we have, the answer to the problem, because there isn't an answer to the problem, or certainly not one that we can see. I think that this is why this emphasis on complementarity, that you need a whole range of different responses, some of which are based on deterrence and enforcement, others which are based on incentives, and so the carrot and sticks approach. I think our thinking is very much in the tradition of responsive regulation, the very famous and Braithwaite approach, which recognizes that people start in different places. Some are already well disposed, others would do the least that they possibly can. And what you need is a mix of incentives and sort of deterrence factors to push people in the socially beneficial direction. So, yes, we're arguing that mechanisms or requirements like disclosure, transition plans, taxonomies, all have a role to play. And we see that in terms of shaping board behavior, management behavior, investor thinking as well. We think this can drive standards upwards and is welcomed by a large number of directors. We also see this as having commercial implications as well, as you judged, because cost of capital, insurance, sort of costs increasingly embedded in potential regulation, and and the like. So there's a whole range of ways in which what we are saying can make a positive difference, but we're not saying that we have the complete answer. And we don't think that, even though we contrast Section 172 reform and regulation, we don't think even that is getting close to a complete answer. There are carrots and sticks, and they all have to be considered.
Yeah, and it is a sort of a whole kind of system and network of interventions that make a difference here. That's fantastic. So much to reflect on there. It's a fascinating paper, and thanks very much for talking to us about it today.
Thank you.